All right, so today we're diving into what looks like a simple legal battle, right? You've got a big company squaring off against a government regulator. But trust me, when you peel back the layers, it gets weird. We're talking about a mystery lawsuit filed hundreds of miles from home, a case that literally hangs on the meaning of just 4 words. And get this, it could change how government agencies are challenged in court forever. And that brings us to the central puzzle. You've got Reynolds Vapor Company. They're based in North Carolina. The agency they're suing, the FDA, over in Washington, D.C. So why on earth was this lawsuit filed in Texas? I mean, it seems totally random, right? Nope. It was a very, very calculated move, and it's the key to this whole thing.
Okay, so let's quickly meet the players. You've got RJR Vapor Co. out of North Carolina. They make the Vuse e-cigarettes. Then there's the FDA, the big federal regulator in D.C., and the lawsuit itself, filed in the Fifth Circuit Court of Appeals, which is in Texas. Yeah, that geographical mismatch, that's our first big clue that something interesting is going on here.
So how did we even get to this point? Well, let's rewind a bit. It all kicks off in 2016 when the FDA decides, hey, e-cigarettes are now new tobacco products and we're going to regulate them. This meant companies like RJR had to apply for permission to sell their stuff. So RJR applies for its super popular Vuse Alto line, but the FDA comes back and says, nope, denied, citing public health concerns. For RJR, that's a massive financial hit. So what do? They sue. And here's the clever part. They partnered up with a retailer in Texas, and that was their ticket to filing the case in the Fifth Circuit.
Now, here's what makes this so wild. The law actually gave RJR 2 perfectly good places to file this lawsuit. They could have gone to the D.C. Circuit, which is kind of the default, or the Fourth Circuit, which covers their home base in North Carolina. But instead, they went way out of their way to file in the Fifth Circuit in Texas. And the big question is, why? The whole strategy, the whole reason for going to Texas, it all boils down to how you read just 4 little words buried deep in the Tobacco Control Act. Seriously, these 4 words are basically the bouncer deciding who gets into the courthouse. And that brings us to the billion-dollar question. The law says that when the FDA denies a product, any person adversely affected can sue. The entire case, and we're talking billions of dollars for the industry, hinges on what that one little phrase actually means. So what does adversely affected even mean? It's not just some casual phrase you throw around. It's what lawyers call a term of art. It's a very specific legal key that unlocks the courthouse door. It determines who has the right or the standing to sue the government. Really, this whole thing boils down to 2 totally different ways of reading this. The FDA took a really narrow view. They said, look, only the applicant who got denied, the manufacturer, RJR, is adversely affected. But RJR and their retailer friends, they argued for a much broader view, saying, hold on, anyone who loses money because of this decision, including the stores that can't sell a product anymore, is adversely affected. All right, let's start with the FDA's side of things. Their argument was that Congress set up this super specific, closed-off process, and because of that, it only makes sense that the path to the courthouse should be just as narrow. The FDA's logic kind of goes like this. Just look at the process. Step 1, the manufacturer sends in a ton of confidential data. Step 2, the FDA reviews that data. Step 3, the FDA issues a final order directly to the manufacturer. You see? The retailers aren't anywhere in that loop. They don't submit anything, they don't get the official order. So the FDA's question was pretty simple. If they're not part of the process, how can they have the right to sue over the outcome? And Justice Ketanji Brown Jackson, who dissented in this case, really nailed this point. She called the whole thing an adjudicatory process between a manufacturer and the FDA and no one else. Basically, a private conversation that retailers weren't invited to. But, of course, RJR and the retailers had a completely different take. And, as it turns out, a much more persuasive one. They basically said the FDA was ignoring the plain English words in the law and decades of legal history. The heart of their argument was just beautiful in its simplicity. Any person means, well, any person. It's right there. They argued that Congress chose that broad language on purpose, and the FDA was just trying to shrink it down to mean only the applicant. And you know what? They had history on their side. The Supreme Court's majority opinion pointed out that this phrase, adversely affected, has a long, well-established history in U.S. law. It's almost always been interpreted broadly. In fact, the Supreme Court has read it broadly in other huge laws, like the Fair Housing Act. The logic is pretty straightforward. If the government does something that directly costs you money, like telling you can't sell a hit product anymore, then you are, by definition, adversely affected. But here's maybe the most powerful piece of evidence they had, and it comes from the Tobacco Control Act itself. See, the law uses different words for different scenarios. When it talks about challenging an application denial, it uses that broad phrase, any person adversely affected. But when it talks about challenging the withdrawal of a product that's already been approved, the law gets super specific. It says only the holder of the application, meaning the manufacturer, can sue. That difference was the absolute linchpin for the Supreme Court. The majority opinion basically said, look, this proves Congress knows exactly how to write a narrow rule when it wants to. The fact they didn't do that here and instead use the broad, any person language, well, that had to be on purpose. So, with these two really strong arguments clashing, the case makes its way all the way up to the Supreme Court. So, how do they decide, and more importantly, what does this decision mean for everyone else? All right, so after all that back and forth about legal history and the meaning of four little words, who won? Did the court go with the FDA's narrow, process-based argument, or the retailer's broad, just read the words argument? The court came down decisively on the side of the retailers. The final ruling is clear. Retailers absolutely can sue the FDA if a manufacturer's application gets denied and it hurts them financially. And this wasn't some squeaker of a decision either. It was 7-2. That's a strong majority, crossing ideological lines, which tells you there was a real consensus that, hey, the plain text of the law matters most. And their reasoning really came full circle back to that legal history we talked about. The court confirmed that when Congress uses a classic legal phrase, a term of art, like any person adversely affected, they mean it in the broad, established way. And that definition includes anyone with a direct financial stake in the outcome, all the way from the big manufacturer down to the corner store. Okay, so what's the big picture takeaway here? What's the real impact? Well, it all comes down to this idea called forum shopping. It's pretty much what it sounds like. It's the strategy of picking a court or a jurisdiction where you think you'll get a friendlier reception. And this brings us right back to our original mystery of why they sued in Texas. By giving retailers the green light to sue, the Supreme Court has basically blown the doors wide open for more forum shopping. Now, a huge national corporation can team up with a small local business pretty much anywhere in the country and strategically pick a court that's maybe known for being a little more skeptical of government agencies. It gives them a home court advantage, even when they're the away team. Which leaves us with one last big question to chew on. Is this a win for the little guy, giving small businesses a real voice to fight back against regulations that could put them out of business? Or is it a giant loophole that lets massive corporations pick their favorite court to try and weaken federal rules? The answer, just like this case, is anything but simple.